a person is serving in position of an officer or a militant of any force raised and maintained outside Uganda and accompanied by the officer of the Defense Force. The above clause is an attempt to reenact Section 117 of the UPDF Act, which was struck down by the Supreme Court for offending Article 28(1), 44C, 128(1) of the Constitution. Such is inimical to the rule of law, good governance, which is a cornerstone of democratic dispersion, and that of other civilized nations and communities across the globe. It also constitutes an egregious attack on judicial independence, thereby contradicting Article 28(2) and 3 of the Constitution, which provides that no person or authority shall interfere with the courts or judicial officers in the exercise of judicial functions, and that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure effectiveness of the courts. See Article 28(2) and 3 of the Constitution. This action amounts to contempt of the Supreme Court, which is criminal, a path that must be avoided by a decent parliament. Right Honourable Speaker, in a locus classicus case...
Do you have to ask a decent, to add a decent parliament? Must you add decent? Nobody doubts that we are decent.
Avoided by our parliament.
So
most obliged.
Expand the word decent.
In the locus classicus case of Liange versus Bakwin 1967, the Sri Lanka Parliament passed a retrospective law affecting the trial of individual accused of attempted coup. The Privy Council found that it sought to alter the course of a particular decision and effectively overturn the jurisdiction. The Indian Supreme Court in Indira Nehru Gandhi versus Raja Nara in 1975 SC 2299, after election was invalidated by the High Court constitutional amendment that was passed to validate the election. The Supreme Court struck the amendment, holding that the Parliament cannot enact legislation that overturns specific judicial decisions. Any legislation passed with the object of annulling the effect of a judicial decision has been held to be an encroachment on the judicial powers, and it is unconstitutional. Your Honor, coming down, there were other authorities that, Right Honourable Speaker, rather, and colleagues, there were other authorities that were cited year after to persuade the House. I had members to peruse through while I go to deal with the second area of dissent. The second area of dissent is illegality in military trials. Your Honor, Right Honourable Speaker, the question of illegality in military trial is ably canvassed by the Supreme Court in the case of Michael Kabaziruka in the above case. Owindolo CJ, in his lead judgment at page 180 and to 185, add this to say, Your Right Honourable Speaker. There are also other vital reasons militating against trials of persons subject to military law for all offences. These courts, as previously held, that there are certain offences that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on court-martial jurisdiction to try such offences. For instance, since terrorism can only be tried by the High Court, which is an ordinarily civil court.
Honorable Court Junior.
Yes, Honor.
Honorable Justice, Chief Justice Omuliro had this to say. Open court, and then you close the court. Somebody will imagine
Most obliged.
that it continues up to the end.
Most obliged.
Close the
Right, Honourable
court
Speaker.
first.
And if I may proceed from where I had stopped, Right Honourable Speaker.
For clarity, say what Chief Justice said, open court, close it, then you bring your statement.
Right Honourable Speaker, the CJ, Justice Owindolo, in his lead judgment at page 180 to 185, had this to say. Open quote. There are also other vital reasons militating against trials of persons subject to military law for all offences. This court has previously has held that there are certain offences that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on a court-martial jurisdiction to try such an offence. For instance, since terrorism can only be tried by High Court, which is an ordinary or civil court, it would be contradictory to try it in the military court as well. And also it would be self-defeating for an offence similar to terrorism to be created under the UPDF Act and then the persons are tried under it, close quote. I find this holding by Mulenga by Justice of the Supreme Court, Justice Mulenga, still correct position of the law, and where jurisdiction is expressly excluded or where the DPP's consent is a prerequisite, the court-martial are not competent to handle that matter, so excluded irrespective of the provision to the contrary. Under the impugned section 117 and 117I, G and H of the UPDF Act, it amounts to duplication to grant jurisdiction to the court-martial over it when, owing to the gravity of these offences, Parliament conferred jurisdiction over them to ordinary courts. The other issue for consideration is the danger possessed by concurrent jurisdiction, where the military courts could try a case that is also before an ordinary court. This would necessitate the establishment of a mechanism between the court-martial and the DPP to manage the cases, beyond mere provisions in the UPDF Act, and the jurisdiction of the court-martial does not take away that of the civil courts. Concurrent trials in both military and ordinary courts for civil offences would also be prejudicial to an accused for a simple reason that it could lead to double jeopardy, as each court could potentially come up with a guilty verdict. Additionally, as already noted, the General Court-Martial and other military courts are subordinate courts. See, in the case of Attorney General versus Uganda Law Society, Constitutional Appeal number 1 of 2006. However, I do not agree with Justice Mulenga's finding, where I held that the General Court Martial is subordinate but not lower than the Court Martial. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means placed in or belonging to a lower rank or class or position, or subject to another authority or control. Assigning an ordinary meaning to the word subordinate, all court martials as subordinate courts created under Article 129 1D can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than that of the High Court is contradictory and has the potential to create an absurdity when it comes to hearing of capital offences. If Parliament desires to grant them the jurisdiction to handle capital cases, then it would need to do so in line with the Constitution. I will return to this later in advisory opinion to explore the option that could be undertaken by Parliament to achieve this effect constitutionally. With this finding, the hearing by all court martials of offences within the jurisdiction of the court martial is unconstitutional under Article 28(1), 44(c), 128(1), 129(d). Close quote. The general rule is that ordinary courts alone have jurisdiction to try civilians. The Supreme Court was unable to find any rational justifiable link between the need to maintain discipline in the army or maintenance of security of Ugandan borders and trials of civilians in the military court tribunals generally. However, having held as above, the Chief Justice made the following orders. A. The provisions of 179, 1, 2, and now 171, 1 and 2 of the UPDF Act.
171 or 177, 1 and 2.
179, 1, and then 1 and 2, and then 177, 1 and 2 of the UPDF Act. Read together with 197.2 and now 197.2, which grants subordinate military courts jurisdiction over capital offences, contravenes Article 129, 1D and Article 126, 1 of the Constitution. Hence, they are unconstitutional. The provisions of Section 119, 1I and G, now 171 and G is unconstitutional to the extent that it permits trials in court martials of civilians who allegedly aided and abetted the commission of service offences or ordinary criminal offences in which a person subject to military law is a principal offender. Right Honourable Speaker, the minority observes, I'll jump D, the minority observes that the Supreme Court's decision had the following effects. The trial of civilians by court is only permissible in exceptional circumstances and only after state has concretely demonstrated to court by verifiable facts and by objective and serious reasons, need and justification for a recourse to a military court. 2. The minority observe that Military courts can only have jurisdiction in relation to specific class or category of persons and specific offences which ordinary courts are not in position to try. 3. The jurisdiction of the court-martial can only extend to cases reserved for specialized courts such as Anti-Corruption Court under the Anti-Corruption Act, International Crimes Division under the Anti-Terrorism Act. 4. Military courts cannot have jurisdiction of offences which require the consent of the deputy. The consent of the DPP. 5. Civilians cannot commit or be tried for service offences even when they abet or aid the commission of offences. 6. Where civilian and military personnel have committed a crime other than a service offence, both be tried in civil courts. In 7, Parliament cannot duplicate offences prescribed in other acts of Parliament to introduce them in the UPDF Act. Colleagues, members of Parliament, the ratio from the above, with a sober appreciation of the provisions of Article 28 of the Constitution, leads to inevitable and incontrovertible conclusion that all persons, militant or otherwise facing criminal trials, have a right to appear before a competent, independent, fair, impartial court or a tribunal with a decision of the Supreme Court. The trial of persons with offences within the exclusive jurisdiction of the civil courts, particularly by the High Court. Military courts are not competent to try such cases. It goes therefore without saying that any trial will still be unconstitutional and will offend the principles of a fair trial. Accordingly, enacting the proposed legislation into law will be a legislation in vain. Common theme among justices of the Supreme Court Common themes among the justices of the Supreme Court was that the General Court Martial is a tribunal and should be kept as such. Right Honourable Speaker, and members, let me conclude on this note. Court martials should be specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with discipline and regulations of the armed forces. By Justice Catherine Bamugemere, Justice of the Supreme Court, at page 41 of our judgment. Colleagues, members of Parliament, having appreciated that the second area of dissent has been appreciated, I would go to
the third area of dissent.
Your Honor, Right Honourable Speaker, offending the doctrine of separation of powers. Modern democracies are typically organized around three branches of government, each playing a crucial and distinctive role. Adjudication in particular is a function and a preserve of the judicial branch of government. Overriding or intrusion would by in any of the other two would inevitably offend the Constitution. The judgment of the Supreme Court covers situations where military under the UPDF Act may depart from this position by only in a very exceptional circumstance that are consistent with demonstrable justification. The Chief Justice at page 78 to 79, quoting Nalwairo in his work, Improving the Administration of Justice by Military Court in Africa, an appraisal of the jurisprudence on human and people's rights, 2019. Held that a host of authorities, I beg your pardon, held that separations of power helps to provide sufficient safeguard to ensure fair hearing by instruments enunciated by the law on independence and impartiality of the court-martial, such as cardinal and core to the administration of justice. The minority are of the view that granting the military through court-martial the unlimited power to try persons with offenses beyond disciplinary ones would be a violation to the doctrine of separation of power beyond its function envisaged in Article 209 of the Constitution. Article 210 of the Constitution, pursuant to which the UPDF was enacted, did not envisage the establishment of a military and judicial function. Such an extension, therefore, can only be handwork of a overzealous but mischievous stretch imagination, rooted, brewed, and bred in imperfection by proposing an amendment which doesn't meet the test of legitimacy, and we invite Parliament to reject this bill to this extent. 3-0, impartiality and independence of the courts. Right Honourable Speaker and colleagues, members of Parliament, the impartiality and independence are not decorative ideals. They are constitutional imperatives grounded on Article 28 of the Constitution. The right to a fair hearing, and Article 128 of the Constitution, independence of the judiciary. Military courts, as a creature of statutes, are subordinate to the constitutional principles and are bound by these standards. Article 128(1) of the Constitution also imposes a requirement as to the objective of the independence of the or tribunals, exercising judicial powers as a safeguard to a fair hearing. It states that in the exercise of judicial powers, the courts shall be independent and shall not be subject to the control or direction of any person or authority. The bill in clauses 35, 36, 38, and 45 provides for various amendments to the UPDF Act, specifically to the provisions establishing courts martial. It creates the following court martials: a unit court martial, divisions court martial, the general court martial. The bill removes the following courts and trial processes: A, the commanding officer or officer commanding; 2B, trial by superior authority; C, court-martial, court of appeal; D, field court-martial; E, summary trial. Despite the aforementioned, the bill did not respond to the orders and recommendations of the Constitutional Appeal number 2 of 2021 Attorney General versus Michael Kabazaruka as far as independence and impartiality is concerned. Colleagues, I am persuaded to take you further to our next point of dissent. Appreciating that you have read what we are talking about. Colleagues, I have seen the labor you've had to listen to this submission because it is aided by legal gymnastics and quoting of cases. But please listen. Let me go to recommendations. Recommendations. The minority finds that the provisions of clauses 30 specifically proposes section 117A. Proposed section 117A is unconstitutional, irregular, and illegal as far as it allows the trial of civilians by military courts in the circumstances that are not exceptional. D. It extends to the jurisdiction of military courts. It extends the jurisdiction of military courts to the entire civilian population and to all offences which ordinary courts are in position to try. C. The bill also extends military courts to cases reserved for specialized courts such as the High Court. D. The bill extends its service, extends service offences to civilians. Minority cautions Parliament that the Supreme Court directed Parliament not to duplicate offences prescribed in other acts of Parliament and introduce them in the UPDF Act, where therefore recommend that the same be rejected. 4.0. Lack of public participation. The Constitution in Article 38, 1 and 2 thereof reaffirms the right of every citizen to participate in the affairs of government in accordance with the law. This includes engaging peaceful activities to influence the policy of government. On Tuesday, 13th of May, the Clerk of Parliament issued notice inviting the public to submit their views to Parliament by or before the 14th day of May 2025. It is clear that by the time of issuing the notice, the bill had not been presented to Parliament in the plenary, which started at 2 p.m. The requirement of public participation is rooted and entrenched in our constitutional framework and must not be cosmetic reasons. Colleagues, various stakeholders were therefore locked out of the process due to this clearly cosmetic semblance. In the view of the minority, this did not meet the required standard of public participation. Indeed, apart from the Attorney General and the sponsoring minister, the committee interacted with only two other stakeholders, that is the DPP and Council Jude Biamukama. One would wonder why a matter of great national importance of this magnitude would only attract two external stakeholders. This is unprecedented in matters of this nature. On this account, in addition to other reasons given in the minority, the minority invites Parliament to reject the bill to the extent proposed herein. This was the conclusion of the minority. Right Honourable Speaker, Whereas reforms within the UPDF Act are necessary to address contemporary security challenges, such reforms must not compromise constitutional rights. Judicial independence or civilian oversight. We, the minority, persuade this Parliament to reconsider the provisions of the UPDF Amendment Bill 2025 to ensure they align to the principles of democracy, rule of law, and respect of human rights. Therefore, the minority unanimously are of the opinion that the General Court Martial and other courts do not have constitutional jurisdiction to try civilians or adjudicate non-disciplinary criminal offences, even if committed by members of the Uganda People's Defence Force under Article 210 of the 1995 Constitution. Parliament's power to legislate for military courts is strictly confined to matters of discipline and removal of the UPDF. Members, military courts are therefore internal discipline bodies, not general criminal courts, and cannot override the constitutional mandate that all criminal justice, including a fair trial right under Article 28 and 44, lies exclusively with the courts of judicature.
Thank you.
Members, this was jointly and severally the report by the minority. Back to submit.
Thank you. Thank you so much. Honourable members, there are two minority reports. Not so, Chair. There are two minority reports.
Right.
Second one, I am not aware, and it offends the rules of procedure, Right Honourable Speaker.
The Right Honourable Speaker, according to the official information we have, is that the opposition are officially boycotting this sitting. I would wonder how my colleagues are masquerading here.
Honourable. Honourable members, opposition is in the house. Opposition is in the house. I see Honourable Kelo, Honourable Kotti, Honourable Olanya, Honourable Santa, Honourable Duru, who has ably presented a report, Honourable Namanya. Honourable members, Legal, did you get a report from?
I've just received a document. Someone came and dumped a document here, but I've just read it is a minority report of the Honourable Jonathan Odur. I was not informed what it was, but I've just read and realized it is
The man is not a friend.
After all, it's a minority.
Yes, Fox.
Thank you, Right Honourable Speaker. Right Honourable Speaker, I rise to move a motion.
No, there is still an issue of the minority of Honourable Dole. which the chair said was not given to him.
Right Honorable Speaker.
Honorable, yes, Honorable Minister.
Right Honorable Speaker, since NRM believes in democracy, we should allow Honorable Dole present to the House.
Honorable Chris.
Thank you very much, Right Honorable Speaker. We make the rules ourselves as Parliament, and we must respect our own rules. Everybody to abuse provisions of our rules. If the rules require that a member dissenting must formally process his report, give it a chair, let it be. Let's not allow abuse of our rules. And therefore, if he has not followed what the rules provide for, we should not listen to that report.
Honorable members, let's not be seen to be suffocating in a member. Let Honorable Bill come up with this report and give us a summary of this report, his areas of dissent. Let him do it.
Thank you very much, Right Honorable Speaker. Madam Speaker, for the record, this morning I made a phone call to the chairman of Legal and Parliamentary Affairs Committee, and I told him on the phone that I have a minority and the chair is here. Secondly, when I reached Parliament, I again notify him on our platform, and then I filed this report with the clerk of our committee, who duly submitted to the clerk of Parliament. It has been duly stamped as received. So the record should show that I am not smuggling, I'm just complying with the rules. Madam Speaker, before I read, I beg these two situations for members to bear with me. First of all, as Honorable Ochero rightly observed, the leader of the opposition, my boss, has led a walkout from this city, and I am his shadow minister for justice and constitutional affairs. You can imagine the situation I'll be. I may finish and I get fired. So allow me to present this report here. Secondly, in tense moments like this, you would beg that members bear with me. During the ruling in the Supreme Court, at myself and many others against the Attorney General, when their lordships had judged 3 against 3, the last judgment was by the Chief Justice then, Bat Katurebe, and when he had begun to read, he informed us that his glasses and the eyes had a problem, and he needed to be rushed to South Africa immediately. I pray when I'm reading this report, my glasses don't fail me. Having said that, Madam Speaker, introduction. This is a minority report in dissent of the majority report of the Joint Committee of Legal and Parliamentary Affairs and the Committee of Defense and Internal Affairs on the Uganda People's Defense Force Amendment Bill 2025. This minority report is brought under Rule 215 of the Rules of Procedure of Parliament, areas of dissent and statement of reasons for dissent. The minority restricts the areas of dissent majorly on the policy and principles, defects in the existing law, remedies proposed in the bill, and specific provisions of the Uganda People's Defense Forces Amendment Bill 2025, touching the court-martial and related matters, including the schedules. Approach. In this minority report, it presents specific thematic areas of dissent, the reasons for the dissent, and explanatory statements for the reasons of dissent, and this minority report is guided by the provisions of the 1995 Constitution of the Republic of Uganda, the applicable subsidiary legislations, and the lead judgment in the Supreme case, Attorney General versus Michael A. Kabaziguruka, Constitutional Appeal number 2 of 2021. Therefore, Right Honorable Speaker, each word, sentence, paragraph in this report has been carefully considered by the minority for justifying the dissent from the main report of the committee. The minority prays that time be allowed for this report to be presented to the House, both verbatim and seriatim. Thank you. Preliminary and substantive discussions on points of law. In this report, the minority raises several points of law in both preliminary and substantive forms. The minority submits that meaningful debates and decisions of Parliament can only take place after the presiding officer has disposed of, by way of a formal ruling, with reasons, all the points of law raised. The presiding officer should not be tempted to sweep under the carpet, fail, or casually dismiss these important issues or points of law raised by the minority. In short, the minority invites the full attention of the presiding officer during the presentation of this report and prays for the rulings to be delivered on record in a timely manner before debate ensues. Breach of Rule 75 of the Rules of Procedure of Parliament on Sub Judice. During the consideration of the bill, the Uganda Law Society brought to the attention of the committee and Parliament an active court case in the East African Court of Justice, which court decisions are binding on Uganda as set out in the landmark precedent case of Among A. Anita versus Attorney General of Uganda and another, reference number 6 of 2012. I produced the letter dated 14th May 2025, and it is addressed to the clerk to Parliament and reads as follows. Reference, the Uganda People's Defense Amendment Bill 2025. Greetings from the Council, Management and staff of Uganda Law Society. In response to your invitation to meet the Joint Committee on Defense and Internal Affairs and Legal and Parliamentary Affairs for consideration of the above captioned bill, for which we are grateful, this is to inform the Joint Committee as follows. 1. The Uganda Law Society received your invitation letter today at 11:50 a.m., scheduling a meeting for 12 p.m. on the same day. With the greatest respect, the time frame is manifestly inadequate for a thorough consideration of the 150-page bill and is incompatible with democratic accountability. 2. Be that as it may, the Uganda Law Society hereby brings to your attention reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda, pending before the East African Court of Justice. Discussing the bill's provision on military courts would inevitably breach the sub judice rule, contrary to Rule 75 of the Rules of Procedure of Parliament of Uganda, Statutory Instrument number 43 of 2025, and Article 38, Sub-Article 2 of the Treaty for Establishment of the East African Community, and potentially contravenes Articles 2, 20, 79, 3, 92, 126, 1, 128, 3, and 287 of the Constitution of the Republic of Uganda. 3. Given the pending litigation, we respectfully request the Joint Committee to urge government to pursue amicable resolution of the dispute before engaging Parliament and on the contested matters. The Uganda Law Society welcomes the opportunity of another invitation to discuss the rest of the bill. Yours, it is signed by Ewan Asimwe Anthony, who is the Vice President of Uganda Law Society. I don't know for what reason why the President was not available to sign. I now beg to lay on table the copy of duly received by the Office of the Clerk, as well as a copy of the reference number 14 of 2025 Uganda Law Society versus the Attorney General of the Republic of Uganda. Madam Speaker, this document is already part of the minutes laid by the committee. If it is not there, I have a copy that I can lay. In the same vein, the minority also draws to the attention of the Right Honorable Speaker of Parliament and Parliament the constitutional application number 01 of 2025, Male Mabirizi K. Kiwanoka versus the Attorney General, filed in the Supreme Court of Uganda on 14 April 2025. And the same has been duly served upon the respondent who is present in this sitting. The gist of that application is that the Supreme Court should determine whether the action of the respondent, who is the Attorney General and Government and Parliament, of proposing and consideration of the Uganda People's Defense Forces Amendment Bill 2025, providing for trials of civilians in the court martial, is contemptuous of the judgment of the Supreme Court in Uganda, in Supreme Court of Uganda, in Attorney General versus Michael, which I have already cited fully. The constitutional application number 01 of 2025, as referred, filed in the Supreme Court, has already been duly served. The respondent, the Attorney General, is present in this House and can confirm or deny the existence of this live case. All that the minority is belaboring by this submission is to demonstrate by all standards that there is a live and active dispute, not only before the East African Court of Justice, but also Uganda's highest court, the Supreme Court. It will be quite embarrassing for Parliament, an institution central to democracy and the rule of law, to carry on with the consideration of the Uganda People's Defense Forces Amendment Bill 2025, well aware of the court cases that touch on the subject matter of the clauses in the bill. The finding of the minority. The minority finds that Parliament proceeding to consider the clauses of the UPDF Amendment Bill 2025 touching the subject matter of trial of civilians in the court martial undermines the core tenets of the rule of law, the doctrine of mutual respect for separation of powers between the executive, legislature, and judiciary. The next is on retrospectivity of legislation contrary to Article 92 of the Constitution of Uganda. Article 92 of the Constitution of the Republic of Uganda on restriction on retrospective legislation states as follows. Parliament shall not pass any law to alter the decisions or judgments of any court as between the parties to the decision or judgment. Decisions or judgments of courts are categorized into two. One in personam and two in rem, to mean against a person and the world at large. In the considered opinion of the minority, that judgment in Constitutional Appeal number 2 of 2021, Attorney General versus Michael K. is firmly binding on the movers of the bill as well as this Parliament. In short, unless Parliament is deliberately and with utmost impunity dismissive of the judgment of the Supreme Court of Uganda, which judgment was led by none other than Honorable the Chief Justice of Uganda, Alphonse C. Owindolo, together with his brother and sister lordships of the Supreme Court, the Honorable Lady Justice Catherine Bamugemerere, the Honorable Lady Justice Monica Kalejera Mugenyi, the Honorable Lady Justice Faith Mwanda, the Honorable Lady Justice Elizabeth Musoke, the Honorable Lady Justice Percy Knight Tuhaise, and the Honorable Justice Mike J. Chibita, who did an splendid job. And I invite members who are still active that when you get children, you can name them after these lordships. And those who cannot get children, when the technology-assisted reproductive law comes in force, you can produce using and name them. One of the best indicators of a progressive democracy is respect for the rule of law, which includes respect for judgments of courts. If this Parliament, in the full glare of right-thinking Ugandans and the entire world, proceeds to disobey the Supreme Court, then this date and year will go down as the official birthday of the dreaded military dictatorship in Uganda, we surely don't wish to be the midwives to deliver this baby at all. Madam Speaker, let it also sink in our minds that at any one point soon in our lifetime, Uganda will have another president other than H.E. Museveni. The next president, as per the law, shall be the commander-in-chief, boss of the court-martial. This House may have already noticed the following names in no particular order of chances of being the president, being discussed in the public domain as potential future presidents starting in 2026 and beyond. The Honorable Akena Jimmy James Michael Obote, the Honorable Chagulanyi Sentamu Robert, the Honorable Amuriat Patrick Oboy, General Kaino Rugaba Muhozi, General Mugisha Muntu, Honorable Norbert Mang, Right Honorable Aneta Mang, Colonel retired Dr. Kiza Warren Besige.
Honorable, I would never wish to be a president. Remove my name from that list. I am satisfied with what I have and I'm even getting out of politics. Don't put my name into this.
Madam Speaker,
No, my name is not for playing. My name is not for jokes.
Madam Speaker, allow me since it's a
Please, my name is not for jokes. I never want.
Yes, I'm
Honorable, it is my name.
Madam Speaker,
Please remove it.
yes, this is a one member's report signed by me, and I can amend it. I want to withdraw. That's what the point I want to
Yeah, withdraw. I'm not part of that.
That although I had said that the names were in the public domain,
public domain.
I beg to withdraw.
I have my own right.
I beg to withdraw and delete and amend this report by deleting the name Right Honorable Anita Among Annette from this report. And I accordingly withdraw and apologize to you, Madam Speaker. Please, the record does it. Please, I invite this House to carefully reflect on each one of them, their soberness, fidelity to the law, ideologies, actions, sentiments, service records, and imagine what each one of them is capable of using such provisions in the bill. The finding. The minority finds that legislating on clauses of the bill that touch on the decision of the Supreme Court, specifically enacting clauses to try civilians and soldiers who commit civilian crimes in the court-martial, contravenes Article 92 of the Constitution of the Republic of Uganda in light of the case of the Attorney General versus Michael K.K., Constitutional Appeal number 2 of 2021. The next point is decent is understanding of the judgment of the Supreme Court in that case. Right Honorable Speaker, during the consideration of the bill in the committee, an issue arose as to whether there was a lead judgment to inform the consideration of the bill, or all judgments of the quorum mattered. The learned Attorney General informed the committee that the judgment of Honorable the Chief Justice, as is the lead judgment, whose final orders and recommendations guided the drafting of the bill. Whereas the minority considered the other judgments as equally important, in as far as several rulings therein, the minority, for purpose of harmony, agreed with the Attorney General to restrict discussions around the lead judgment of Honorable the Chief Justice, Alphonse C. Owindolo, who listed 6 specific issues that the Supreme Court was required to resolve, and the issues are as follows. The first was whether the court-martial are courts established under the Constitution or are mere tribunals. 2, whether the court-martial can be or are independent and impartial within the meaning of Article 28 of the Constitution. Whether civilians can legally be liable to face trial in the court-martial for disciplinary offences, herein called military, disciplinary or service offences, stipulated in Part 6 of the UPDF Act. 4, whether civilians can constitutionally or legally be tried in the courts-martial for civil offences not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislation. 5, whether it is constitutional for persons subject to military law to be tried in the court-martial for offences outside the UPDF Act, herein called civil offences. 6, whether it is constitutional for civilians to be tried by the court-martial as principal for offences under sections 1, 191H of the UPDF Act. Yet all those also exist in the civilian offences. Right Honourable Speaker, the minority has found it necessary to briefly highlight the decision of the Supreme Court in each of the questions, as this will be extremely important. First, in refreshing the memory of the members. Then secondly, and most importantly, guiding the members to properly direct their minds during the debate on the principles and justification of the bill. On the first issue, number one, whether court-martials are courts established under the Constitution or a mere tribunal. In answering this question, Right Honourable Speaker, which answer was agreeable to the rest of the panel, Honourable the Chief Justice Alphonse C. Owindolo wrote on page 44, paragraph 15 as follows: I would therefore hold the General Court Martial is not merely a complementary court to civil courts. It is established as a court which is, however, seized with specialized jurisdiction. The take home from this answer is therefore twofold. One is that the Supreme Court recognized the existence of court-martial as a creature of law. And secondly, but most importantly, its special status, implying it is meant for specialized cases only. I now quote the learned Attorney General of Uganda in a letter which I also beg to lay, I believe is part of the documents laid, written on the 3rd February 2025, addressed to the Honourable Minister of Defence, addressed to the following: Honourable Minister of Defence, the Chief of Defence Forces, the Chief of Joint Staff, and Director of Public Prosecutions, in paragraph 2 on page 2 and paragraph 9 on page 3, reproduced below. This, I quote what the Attorney General wrote. Section 197, now Section 195 of the UPDF Act, which establishes the General Court Martial, is duly established under the law as a competent court, is constitutional. The Attorney General said, our understanding of the above declaration is that the General Court Martial is duly established under the law and its existence is consistent with the Constitution. However, it must be clothed with the following attributes. A. Members of the General Court Martial must be persons with requisite legal qualifications. B. The members of the General Court Martial should be independent of the command and have security of tenure. C. There should be adequate time and facilitation in the preparation of defense by an accused person, as well as a right of an accused person to due process and an appeal in capital offences. D. The convening authority must lie with the General Court Martial, which guarantees institutional independence from the authority prosecuting the case. This is what the Attorney General advised, and it will help us when we come to closing. It is Attorney General further writes, sections 2, 179, 119, 1H and G, now respectively 177, 10X, 1171H and G of the UPDF Act are unconstitutional, since they confer blanket jurisdiction on court-martials to try civilians. Our understanding, this is what the Attorney General wrote, our understanding, the understanding of the Attorney General of this declaration 7, 8 and 9 by the court is that civilians cannot be tried in military courts. Our understanding of these declarations 7, 8 and 9 by the court is that civilians cannot be tried by military courts. I quote from the Attorney General. The minority recognizes the mandate of the Office of the Attorney General under Article 1193 and 4 of the Constitution of the Republic of Uganda, to wit, shall be the principal legal advisor of government and to give legal advice and legal services to government on any subject. It may be recalled, Right Honourable Speaker, that in both the original constitutional petition number 45 of 2016, Honourable Michael A. Kabaziguruka versus the Attorney General in the Constitutional Court, and in the Constitutional Appeal number 2 of 2021, the Attorney General versus Honourable Michael K. The Attorney General diligently and professionally offered legal services representation in court and lost all the arguments except the legality of existence and creation of the court-martial. However, how then does the executive and even parliament expect the same learned attorney general to again go back to the constitutional court and Supreme Court to defend the same issues which he argued and lost? It must be very burdensome, tiresome, hopeless and frustrating to be a lawyer to the government in such scenarios. Sympathies to the learned attorney general, Honorable Kiwanuka, and the team of learned friends in the chambers of the attorney general who prosecuted the case. Can they even dare face the same court again on the same issues already decided by court? Finding. And I must say, on a lighter note, Madam Speaker, a former Attorney General William, Senior Counsel William Biarohanga, I'm reliably informed, asked to be excused from executing role of Attorney General. Then another Deputy Attorney General who was with us here, Honorable Mwesigar Kutana, immediately he left this role. He had the energy to marry even a young wife. So it is really burdensome to be an Attorney General.
Honorable Duru, you're going personal.
Please, I withdraw.
He has nothing. I mean, what's wrong with marrying a wife?
Finding. I withdraw, Madam Speaker. Finding. The minority, therefore, finds that there is no legal basis to provide for trial of civilians in the military court as decided by the two highest courts of Uganda, Constitutional Court and the Supreme Court. The minority further finds that there is no political, ideological and security narration to justify enactment to provide for trial of non-military offenses in the court-martial, and therefore is shallow, unreasonable and unconstitutional. Court-martials, as found by the Supreme Court, are established legally, hence there is no need to re-establish it. Court-martials, as found by the Supreme Court, and this is what I want members to pay attention to, are already established legally, hence there is no need to re-establish it. The question of restructuring of the court-martial is necessary, but as shall be later pointed out, not possible through provisions of the proposed bill. Subordination of the court-martial. That's the next point of dissent. The Honorable the Chief Justice, Alphonse C. Owindolo, in his judgment, found as quoted below. Additionally, I open the quote, additionally, as already noted, the General Court-Martial and other military courts are all subordinate courts. See the case of Attorney General versus Uganda Law Society, Constitutional Appeal number 1 of 2006. However, I do not agree with Mulenga, Justice of the Supreme Court's finding, where he held that the General Court-Martial is subordinate, but not lower than the High Court. According to the Black Laws Dictionary, Brian A. Ghana, 8th edition, subordinate means placement in or belonging to a lower rank, class or position, or subject to another's authority or control. Assigning the ordinary English meaning to the word subordinate, all court-martials are subordinate courts created under Article 129, 1, sub-article D, and can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than the High Court is contradictory and has potential to create an absurdity when it comes to hearing of capital offences. If Parliament desires to grant them jurisdiction to handle capital offences, then it would need to do so in line with the Constitution. The minority observes, Madam Speaker, that Article 129 of the Constitution of the Republic of Uganda provides for the courts of judicature as stated in the judgment. Article 129(1), the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and D, which is underlined, such subordinate courts as Parliament may by law establish, including the Cadi's Court for marriage, divorce, inheritance of property, guardianship, as may be prescribed by Parliament. Article 129 of the Constitution is on the jurisdiction of the High Court and states as follows, and we can read together. 1. The High Court shall, subject to the provisions of this Constitution, have unlimited original jurisdiction on all matters, and such appellant and other jurisdictions as may be conferred on by this constitution or other law. In light of the judgment of the Supreme Court, Madam Speaker, any court created by Parliament is inherently subordinate to the High Court. Any court created by this Parliament, whether we go ahead and create or not, is inherently by this provision of the Constitution subordinate. We cannot create a court equal or higher. For any court to be created with either the same or higher jurisdiction to the High Court, it has to be directly created in the Constitution under Article 129, sub-Article 1, and listed either in, you can reflect, in Clause 1C with the High Court, meaning at the same level, or immediately before Clause 1D to exclude it from the subordination. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129, other courts other than the three courts of record. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129B, which we are about to do, of the Constitution is equivalent to amending Article 139. Sub-Article 1 of the Constitution, to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution of the High Court. I can repeat that. The minority observes further that conferring unlimited original jurisdiction on courts created under Article 129D, such as the court-martial of the Constitution, is equivalent to amending by infection Article 139(1) of the Constitution to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution on the High Court. Is it therefore allowed to amend the Constitution through an amendment of an Act of Parliament? The obvious answer is no. The Constitution can only be amended in conformity to Chapter 18, Articles 259 to 263 of the Constitution of the Republic of Uganda. The minority submits that the UPDF Amendment Bill 2025 is not a bill for an act to amend the Constitution, and therefore cannot attempt by trickery or any other means, including fraud, purport to amend Article 139 of the Constitution of the Republic of Uganda. Right, Honorable Speaker, the advisory order recommendations of the Supreme Court are stated in paragraph 10 on page 199, bullets E of the judgment of the Honorable, the Chief Justice Alphonse C. Owindol as follows. E, amend the Constitution, and pay attention, this is what the Chief Justice ordered or recommended. Amend the Constitution to establish superior courts within the military court system under Article 129, and clothe those courts created by amendment of the Constitution with the requisite jurisdiction and guarantee of independence and impartiality to try specific military offenses under existing laws committed by military personnel. F, the Chief Justice advised, provide in the UPDF Act for the High Court, which is already created and in existence, to sit as a court-martial with power to try all criminal capital offenses within the High Court's jurisdiction, and those unique to the military that attract maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can therefore act as assessors. Appeals to the court-martial appeals court would follow the same format, with Court of Appeals sitting aside. Magistrates' courts would assume the jurisdictions all over other offenses of a subordinate court. G, the Chief Justice says, make provisions in the UPDF Act for trials of civilian in the military courts to be only under limited circumstances, and only after the state concretely demonstrates to the court by verifiable facts and by objective and serious reasons, the need and justifications for recourse to the military courts. This must only apply where, in relation to the specific class or category of persons, offences in question, ordinary courts are not in position to undertake. This is the quote of the Chief Justice upon which this bill has been brought. The understanding of the minority on these advisory orders E to F and G above is that they are premised on the fact that all trials of both civilians and military personnel who commit non-service military offences must be before civilian courts. In other words, the current civilian courts, Magistrates Court, High Court, Court of Appeal and Supreme Court are all competent by all standards required under Article 28 and 44 of the Constitution of the Republic of Uganda to try any offence in the law books of Uganda. A question was put to the learned Attorney General on whether his trust, confidence and belief, a question was put to the Attorney General on where his trust, confidence and belief would lie in delivery of justice on the offences proposed in the bill. Were those trials to take place premised on the same facts before either the civilian courts or the court-martial? So we have two sets of same offences. Which of the two courts would the Attorney General trust? The learned Attorney General answered that both courts can and will deliver justice. The understanding of the minority on this answer is that the learned Attorney General confirmed that civilian courts in existence right now is capable of conducting any trial of criminal nature in Uganda without need to waste time and resources on the court-martial, which has unconstitutional structure. The structure, not the court-martial. The court-martial is constitutional, but its structure has unconstitutional structure, incapable of delivering a free, fair, and impartial justice to any accused person. Even, Madam Speaker, even if this answer is denied, the question to the government and the mover of the bill is the government of NRM in power for 39 years and who virtually recruited and appointed all the cadres, the investigators, the police, the prosecutors, office of the DPP, the arbitrators, the judicial officers, if we check on the record of the current structure of police, leadership, and the rest, all of them have been recruited by this government. Are they therefore justified to complain on the incompetence, the weakness in the judicial system? The question is, the NRM government in power for 39 years and who recruited and appointed all the cadres in the justice system, the police, prosecutors, and the arbitrators, the judicial officers, are they justified to complain on the incompetence, weakness in the civil courts to handle any case in Uganda? If the minority was granted more time, Right Honourable Speaker, it would have produced on record all cases of murder, aggravated robberies, terrorism proposed in the bill against accused persons, including military personnel, which has been successfully prosecuted in the civilian courts. By the time of writing this report, Madam Speaker, I had not known that yesterday the High Court convicted a former soldier, a militant, of an offence. That further demonstrates and strengthens my argument that actually the civilian courts right now can convict, try and convict, murder, aggravated robbery, etc. The minority invites the attention of members, especially those familiar with court papers, to reflect on the proposal of the Chief Justice, which captures the spirit of the advisory orders by the Chief Justice as follows. I have put a heading there just to illustrate when we come to the amendment. All the headings of courts in Uganda would be written the Republic of Uganda. In the High Court of Uganda, it could be in Kampala, the example, and in bracket, we put the provision for court-martial / military division. That is what the learned Chief Justice had advised. Finding, the minority finds that the proposals in the Uganda People's Defence Forces Amendment, Bill 2025, purporting to recreate the court-martial with unlimited original jurisdiction is unconstitutional, as it inadvertently amends Article 139 of the Constitution of Uganda without following the procedure of amendment provided under Chapter 18 of the same Constitution. The minority further finds that it is administratively viable to provide for a specialized court within the civilian courts for purpose of trial of criminal offences committed by the military person. The next point of dissent is on limited or exceptional circumstances, as has been said. Madam Speaker, the minority recognizes the discussion in the judgment on the limited circumstances of trials of civilians and or military persons in the court-martial in Uganda. In the judgment, the minority understands that these circumstances appear to be strictly in reference to a situation where, and we can pay attention, one, the constitution is not in force, similar to the military rule during Idi Amin's regime. That is the first condition for trial of civilians in the military court. There must not be constitution in force. Two, courts of law have no capacity to try the offences. For example, there are shortages of competent judicial officers. Three, soldiers and civilians are on duty or deployed in a foreign land where there is no possibility of returning them for trial in Uganda, and there is no other court in that country to try the accused. We all know where our army, the UPDF, are deployed, so the court martials can try them there in case that country does not have a law or the situation of the war in that country. That is the understanding of the minority. The scenario of Karamoja, which was presented in the committee as a success story of the court-martial, was unjustified. It was claimed that judicial officers had feared to be deployed in Karamoja to hear cases because of insecurity. These are the questions. Were other courts in the neighboring districts also unavailable to try those cases? Did the same government demonstrate to Ugandans that courts in Karamoja were fully functional when Colonel retired Dr. Kiza Besigye was flown to Moroto and charged in the civilian courts? Who is mandated to ensure law and order in Uganda, and why not deal with the root causes of it all, which is the security of the judicial officers rather than recourse to the courts-martial? Madam Speaker, were the trials free and fair in Karamoja? The presumption of innocence, the charge sheets, were they read through them? Did they take proper plea? Did they give evidence as per the Evidence Act? Was there a ruling on the prima facie case? Was there a defense? Were there the convictions? Did they allow them to plead to mitigate? And what was the sentencing guideline? In the opinion of the minority, it is foolish to legislate to provide for unconstitutional situations, like providing for scenarios where the constitution laws are not enforced. All I am saying, Parliament cannot sit and legislate for a situation where the constitution is not. It would be foolish of us to do that. And as such, to make,
At least not everybody is foolish.
no, I just said it is. I didn't accuse anybody. Right, Honorable Speaker, to make all Ugandans liable for trial in the military justice system. First, all Ugandans, Madam Speaker, to make all Ugandans liable for trial in the military justice system, first of justice system,